Good afternoon and welcome. I'm Kayla Hooven with Foley and Lardner. I'm pleased to welcome you to today's web conference titled Insider Trading After the Supreme Court's Friends and Family Ruling in Salman. Today's presenters are Jonathan Halpern and Beth Boland. Jonathan leads the Government Enforcement, Compliance and White Collar Practice in Foley's New York office, and Beth is Vice Chair of the Litigation Department and Chair of the Securities Enforcement and Litigation Group. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help widget below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can get a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. And now I'd like to turn the presentation over to Jonathan Halpern.
Thank you very much, Kayla, and welcome everyone. We're delighted that you are attending today, and we are delighted that we can present this webinar on a very timely topic. It's my pleasure to have Beth Boland join me in this webinar. Beth serves and is headquartered in the Boston office. She represents clients in shareholder suits, the SEC, and Attorney General investigation and consumer class actions. She represents corporations and institutional investors in connection with insider trading issues, accounting fraud, corporate control issues, and many other matters. My name is Jonathan Halpern. As for me, on the government side, I used to be a federal prosecutor here in the Southern District of New York and was chief of the Major Crimes Unit. In private practice, I've had a broad white-collar defense practice, including internal investigations, FCPA, insider trading and securities matters, representing multinational pharmaceutical companies, as well as in the financial services industry, investment funds and other companies, and individuals in a wide array of criminal and regulatory matters for the Justice Department, the SEC, the U.S. Attorney's Office, and State Attorneys General's offices. I will note that one of my insider trading representations was of a key government witness, Sid Gilman, who testified under a non-prosecution agreement in the Matthew Martoma insider trading case. The prosecution, the trial and conviction was 3 years ago, and we'll talk some about that case and some others and some of the issues of personal benefit as they relate allegedly to tippers, as it did allegedly to Gilman as a Martoma tipper. That issue has been raised on appeal, and now the question of any application of the Salman case has been raised there as well. So speaking of the Salman case, let's get to it. We'll start with just an overview of what the areas that we intend to cover in this webinar. First, a summary of the legal issue and the Supreme Court ruling in the Salman case. A brief summary of tippee liability principles. The underpinnings of Salman is the Supreme Court case Dirks versus SEC, and in fact, there are more than underpinnings that almost overrides Justice Alito's opinion. We'll touch on the circuit split between the Second and the Ninth Circuit, their arguments to the Salman court as to personal benefit. We'll look at Salman, obviously, the trial evidence and the Supreme Court ruling. And then we'll turn to implications in the aftermath of Salman, the kinds of questions that continue to be raised and those that were not addressed in the Salman decision. We'll look at some of the effect on pending cases, and we'll conclude. And we say at this point that we encourage you all to think about questions you'd like to put to Beth and me during the course of the webinar, and certainly after the webinar today and thereafter we'll be available to address questions that you may have. So we encourage your submitting them through the chatting device or directly to us. So let me turn next to the tipping trading friends and family. This is the issue that's presented to the Supreme Court in Salman, and a summary of the issue before the court. Does a corporate insider, a tipper, derive a personal benefit by gifting his company's confidential information to a trading relative or friend, even if he receives no financial or other tangible benefit in return? The issue before the Supreme Court in Salman was very narrow. It relates to the transfer of information to the trading relative or friend, even though Salman himself, as the ultimate recipient, was both an extended relative of the tipper, an even greater extended relative of the direct tippee with whom Salman was a friend. We'll get into the weeds a little bit more, but the issue before the court was on whether the tipper derives a personal benefit, in this case by gifting the company's inside information to his own brother, and in that context whether a personal benefit is presumed or may be inferred by the fact finder, either a jury or a judge in a bench trial. So the significance of the issue is that whether the tipper breached his fiduciary duty by gifting the information, and by doing so is he subject to insider trading liability. The court responded to the issue by saying yes, giving, transferring, providing, revealing such information, confidential, material, non-public information, to a trading relative or friend can be sufficient for insider trading liability. A little bit more on the, a little background on the tipping liability. So a tipper owes a duty of confidentiality and trust to, in the classic sense of a corporation, to the shareholders of that corporation. And by both disclosing confidential information without or in exchange for a personal benefit, generally something of value, cash or other tangible pecuniary interest, that constitutes a violation of that insider's duty of trust, and that would constitute a breach of fiduciary duty. However, merely disclosing the information, the confidential information, without receiving or deriving a personal benefit, does not qualify as a breach of fiduciary duty. So the issue before the court was, is there some personal benefit that inures to the tipper himself or herself? Does the tipper derive a personal benefit merely by transferring confidential information of his company to a trading friend or trading relative, and without receiving any more, and therefore the court was to determine whether that was sufficient to constitute, one, a personal benefit, and two, that would mean that there was a violation through a breach of the duty of trust, and therefore the tipper would be liable for insider trading, and the tippee as well, if the trading tippee is liable if he knows about the insider's gift, and that would be the case downstream through remote trading tippees. It may be the case, just as an aside, that downstream the tippees owe a duty to their supplier, the source, their source of the information. That would be under a misappropriation theory, but we've got this personal benefits issue, and the courts have essentially said that should apply to both theories. Okay, next slide. Here are the underpinnings of the Supreme Court's decision from Dirks. And Dirks, as said, is a Supreme Court case in 1983, and there the Dirks court rejected the theory that a recipient must refrain from trading whenever he receives inside information from an insider. Even cites the SEC as recognizing the value of analysts' work to the entire market and to the benefit of all investors. And throughout Dirks, there is a running theme that the mere disclosure of even confidential information is not in and of itself a violation, at least of this duty of trust for purposes of insider trading liability. The need to look to the purpose, the intent. Was there any desire to obtain a benefit, a personal benefit, either through reputation, earnings, or the like? And so, as essentially said, there's no breach of duty unless the personal benefit is received in exchange for the tipped information. A breach of duty occurs if the insider will benefit directly or indirectly from his disclosure. Absent some personal gain, there has been no breach of duty. Again, this duty arises, it's in connection with the relationship between the parties, the tipper, the tippee, not merely from one's ability to acquire information because of the position in the market. And the court, again, this is in Dirks, focused on whether the insider receives a pecuniary gain or some other benefit, as I mentioned, such as to reputation, that will translate into future earnings. Or was there a close relationship between insider and the recipient, suggesting a quid pro quo from the latter, that is a gift of confidential information to a trading relative or friend. And that comes from Dirks itself, though it didn't expressly say that the trading where a tipper receives something of value in exchange for a tip or makes a gift of confidential information to a trading relative or friend. But in the Dirks case, where the court looked at it, it said they're first looking at the objective facts and circumstances of the case, such as the relationship between the insider and the recipient that suggests a quid pro quo from the latter or an intention to benefit the particular recipient. And they said that the Supreme Court in Dirks, that the elements of fiduciary duty and exploitation of non-public information also exist, quote, when an insider makes a gift of confidential information to a trading relative or friend. And that's really the basis for the 8-0 decision that Judge Alito delivered in Salman. In the Dirks case, since Dirks, as an insider, had disclosed almost as a whistleblower in order to expose fraud, but not for any personal benefit, there was no duty, or no breach of duty, and therefore no tipping liability. In that case, the insider was an insurance company. It was to Dirks, who was the broker-dealer analyst, and the insider was concerned that the company's assets were overstated because of various allegations of fraud. There was an attempt to reach out to various regulators who failed to act on these claims. He was seeking to verify the fraud and disclose it publicly. He disclosed it to Dirks for Dirks to undertake an investigation. And from there, I'm not going to tell the whole story, but there were various disclosures. I should say that, Dirks is obviously a very important case. The seminal case goes back to 1983. It's relied on heavily by Justice Alito in Salmon. I would say roughly 70 or more percent either quoted or paraphrased of the Dirks case. And it's just a terrific read by Justice Powell. I would suggest that not on a night like tonight, but on some cold wintry night, perhaps before a roaring fire, might want to pour a stiff drink, perhaps a single malt, and then curl up to the fire with a copy of Dirks versus SEC 463 U.S. 646. It's I say not a whodunit, but it is a very good page turner, and more seriously, I mean, it does reveal a very thoughtful analysis. It's been the foundation for insider trading cases on tipper and tippee liability for now over 30 years. As I said, Justice Alito has relied on it, and I just commend it to you for just knowledge and just really well done. So next, let me just touch on the circuit conflicts that led to Salmon in the Supreme Court, and this is between the Second and the Ninth Circuits on the issue of a personal benefit. And this is where personal benefit, where material non-public information was gifted to a trading relative or friend, and they have to trade if you're just providing the information to a relative or friend. It also suggests that there's not the intent of the tipper for the relative or friend to trade, to act on that information. And so under Newman, the Second Circuit said that essentially its read of the Supreme Court case Dirks does not permit the fact finder, jury, or judge in a bench trial to infer a personal benefit, again, to the tipper, unless there is a proof of a meaningfully close personal relationship between the tipper and tippee that generates an exchange that is objective, consequential, and represents at least a potential gain of pecuniary or similarly valuable nature. And so, again, that's in the context of a tipper's gifting confidential information to a trading relative or trial, a friend rather, trading relative or friend, and the Second Circuit is saying, even so, you need more. Okay, let's say you have a close personal relationship, but you need something that is going to be effectively similar to a quid pro quo, or the potential, the meaningful, significant, consequential, tangible, or perhaps even to reputation. But it's something that you need to be able to identify. The Ninth Circuit said, no, this was in the Salmon case itself. It said no further proof is required for personal benefit, at least to be inferred as the tipper derives a personal benefit. That's based on their reading of Dirks. So that's what's queued up for the Supreme Court. The Supreme Court essentially just followed Dirks. But let's first talk about the trial evidence. The tipper, the insider, Mayor Cara, was an investment banker at Citigroup, no longer, but was at the time, worked with highly confidential merger and acquisition information regarding Citi clients. That insider shared that information, or some of it, with his older brother, Michael. Initially, there was testimony that it wasn't to benefit Michael in terms of trading, but over time, that trading relationship or that transfer relationship morphed into one in which the insider understood that his brother was in fact going to trade. And he did trade, that is Michael, The brothers, there was testimony, enjoyed a very close relationship. Michael was looked as a second father. He was the best man at Mayer's wedding. To make things a little more interesting, it was a wedding to Salman, the petitioner's sister. And so over time, Michael and Salman became friends. There was also an extended relative, and the relative in the case, obviously, we've got the two brothers, the inciting brother who becomes Salman's brother-in-law, marrying his sister. So there is a very close relationship, and I think Justice Alito goes to some measure to point out that this is a close relation, that they're close relatives, and so that's one way to fit this in the construct that was set forth in Dirks. Should make note right here, there's no definition that Justice Alito gives about as to what constitutes a sufficient relationship or relative, how close do you have to be, nor is there a definition of friend. Beth will touch on some of these issues in her comments. So we have here Michael traded for himself on the confidential information, and he also passed it along to Salman, the petitioner, and others. Salman himself traded. He scored more than $1.5 million in profits, which he shared with a partner who affected some of the trades. The two brothers, Mayer and Michael, pled guilty and testified for the government at Salman's trial. Salman was convicted of conspiracy and 4 counts of substantive securities fraud. He was sentenced to 36 months imprisonment to be followed by 3 years of supervised release, and was to pay $730,000 in restitution. Some of these arguments to the Supreme Court in Salman that the petitioner made, he's saying this is in connection with Mayer's gift of confidential information about Citigroup and its customers, its clients, to a trading friend or relative. And according to Salman, that was not sufficient for securities fraud. For personal benefit, in this case, the tippee who was placing the trade needed to obtain money, property, something of tangible value, something akin to other frauds, such as bank fraud or wire fraud, mail fraud. And that the second point is that without tangible monetary profit, the insider tipper derived no personal benefit. There was no evidence that Mayer, as the insider, received anything of value, any gift, any of the proceeds from the sales, from the tipped information, or anything else other than the enjoyment of the relationship with his brother as a relative. The petitioner also made some other arguments to the court that this was overbroad and indeterminate, and the court just struck those down. The government's position takes a very broad, sweeping approach. Essentially, it says that the standard should be that the disclosure of confidential information by the insider to anyone, not just a trading relative or friend, is sufficient to prove securities fraud. And as it explains, that's as long as it's for not a personal or a non-corporate person. That is, if it is for a personal or a non-corporate purpose, then that's securities fraud, insider trading, the mere disclosure of that to anyone. Only if it's for a corporate purpose should it not be considered a breach of duty, a breach of trust and confidence, a breach of fiduciary duty. That was the government's position. The Supreme Court declined to accept either position, the petitioners or the government's. Instead, it took a very narrow decision. It was drawn directly from Dirks, as I've said. The personal benefit may be inferred where the tipper makes a gift of confidential information to a trading relative or friend. And that's quoting from Dirks. So that was the narrow issue that the court identified. It's whether that, as they term it, a gift of confidential information to the trading relative constitutes a personal benefit. And nothing more was needed, unlike the Second Circuit in Newman, saying that you needed to go beyond and effectively at least identify a significant consequential benefit, something akin to a quid pro quo, or the prospect of that. Justice Alito says, no, we have our answer in Dirks. It's very clear. This was the language of Dirks. It's set out, essentially, end of story. No further guidance, no analysis as to what type of friend or relative is required, but does say that this is that it's an inference that the fact finder may make, and Beth will touch on that issue as to whether that's something that's compelled, such as, but in here it just gives the fact finder the opportunity to conclude that it is sufficient for a personal benefit. And here the court analogizes an insider's gift of confidential information to the tipper's own trade and the subsequent gift of the sale proceeds to the tippee, and says it is obvious that Mayer, the insider, would personally benefit in that situation. I'm not so sure why it's obvious that there would be a personal benefit to the tipper, who's either directly tipping inside information to the tippee or on his own trading on that information and then conferring the cash proceeds, transferring the cash proceeds to the tippee. It's not entirely obvious to me. I will say, though, that back in Dirks cites an article from the Harvard Law Review which espouses the theory that says that the insider, by giving the information out selectively, is in effect selling the information to its recipient for cash, reciprocal information, or other things of value for himself. So it's an inference. It's a little bit of a stretch, but that appears to be what was driving Dirks to make up that personal benefit test, and which continues to have effect now in the Salman case. So again, unless the tipper receives or derives a personal benefit, the disclosure of confidential information may well violate other procedures, rules, but in terms of securities fraud, insider trading, liability, the court is saying you have to have a breach of fiduciary duty, and you don't absent a personal benefit. So the court goes on to cite, to paraphrase, to praise Dirks, to say this is really controlling. It's essentially the Bible. Go look to it. And its rationale, as he says, is the tipper benefits personally because giving a gift of trading information is the same thing as trading by the tipper, followed by a gift of the proceeds. Why the tipper then necessarily or automatically benefits as a result of the gifts that he or she is conferring, not so clear to me, but we have that theory laid out in the Law Review article that Dirks cites. So yet another reason to go back to read Dirks. I will end with this focus on the effect on the Newman case, the Second Circuit case, that the Salman says essentially there's no effect on the reversal of the convictions of these remote traders. And in that case, the defendants were downstream tippees. There was testimony, or there was a lack of evidence, that these tippees knew the source of the information, knew that it was from a corporate insider. And just like for a direct tippee, a downstream tippee is required to know for insider trading liability that the insider breached that fiduciary duty, and did that, again, two ways. One, by disclosing confidential information, material non-public information, and knowing that the insider disclosed the confidential information in exchange for a personal benefit. The slight carve-out is when that exchange is to a trading friend or relative, but still they'd have to have, the tippee would have to have the knowledge that the information was exchanged to a trading friend or relative. So this decision, which really focused on personal benefit, did not implicate the issues, at least as to these traders, their knowledge as remote tippees, and that's what it says. Does not implicate the issue of whether the defendants must know the source of their information, or that the insiders received a personal benefit in exchange for the tips. Again, in Salman, Mayor Kara, who was the insider, did not receive a personal benefit other than what Nave derived by giving it to his brother. And so unanswered, and what Beth will address are what constitutes a friend, how close a friend, how close a relative, other issues if it doesn't fit into that category, what other principles do you apply, such as Dirks or Newman. And the court did go on to say that the Newman standard for determining a personal benefit goes beyond what Dirks required, and to that extent appears to have shut that down in the context of personal benefit to a friend or relative, although there is now some argument in the number of the district court and appellate cases that were pending while Salman was being decided, and then was decided a little over a month ago. So with that, happily turn this over to Beth to pick it up.
Great,
Beth?
Thanks, Jonathan. And Kayla, do we have a CLE code for our audience?
Yes, so if you are in need of CLE credit today, please enter the 5-digit code below into the poll question on the screen after it's announced and press the submit button. The code is REOZB. Again, that's R as in red, E as in elephant, O as in orange, Z as in zebra, E as in boy. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately after the program. A copy of the form can be found in a resource list widget. As a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference meeting. At this time, the poll is now closed. I will return to class.
Okay, so that code again is REOZB. And I guess the window opens up again later for that. So now that Jonathan has given the lead up to the Salman decision, both in terms of the philosophical underpinnings by the Dirks court, as well as the interrelationship or lack thereof with Newman, let's talk about what the implications are and the questions that Salman doesn't answer and where we think the battlefield is going to be on a go-forward basis. As Jonathan touched on, the touchstone of the Salman case was its affirmation, its real embrace of that personal benefit standard from Dirks. And as those of you, this is actually the third webinar that Jonathan and I have done on the Dirks and Newman and now Salman hierarchy or lead up. And as you may recall, for those of you who've been on these webinars before, we talked in past webinars a lot about what Dirks meant. And for Dirks, as Jonathan mentioned, it is a good read, But the key takeaway really is that the Supreme Court, squarely came down and said that stolen information is not like a stolen car. You really have to look back at the purpose of why the person took the information and why they were transmitting it to someone else. And more to the point, it's not just a breach of duty that is required by that, but a breach of the duty of loyalty. There had to have been something in it for them. And in that way, the Supreme Court was able to distinguish merely passing along information that might have been stolen or misappropriated or whatnot from in a totally legitimate way. In Dirks' case, it was for a person inside the company who wanted to rectify what they thought was fraud going on inside of the company. Analysts play a very important role, and the Supreme Court was really trying to balance the very legitimate disclosure of what could be seen as confidential information from the illegitimate disclosure. So in so doing, they embraced that personal benefit test, really a breach of duty of loyalty, put another way. And they rejected the government's argument, as Jonathan alluded to, that the whole world, anybody who takes inside information, material, non-public information, and gives it away can be liable unless they can show that it was for a corporate corporate purpose. So the Supreme Court said, no, that's too broad, but the Newman test was too narrow. In Newman, as you'll recall, the Second Circuit said that you need to have a, quote, potential gain of pecuniary or similarly valuable nature. The Salman defendant said, well, that means that it needs to be a tangible monetary profit or a tangible value. And the Supreme Court said, no, that's too narrow. Government's definition is too broad. The Salman defendant and the Newman court's definitions are too narrow. And here's the gloss that they put on it, and I think this is what we need to keep in mind as we look ahead to future cases, is in the Supreme Court, in Justice Alito's mind, the real test of figuring out personal benefit is whether when a person who discloses information, material non-public information, to another person can be deemed to have done so for personal benefit, whether it's the rough equivalent of that person trading on that information itself and taking the cash, the proceeds from that, and giving it to somebody else, which is clearly unlawful. And so the court said, so really what's the difference then if you then give that information to somebody else when you're getting something else in return, that personal benefit? So the two takeaways that we're going to talk about now are the standard that the court adopted or readopted from the Dirks case and the quantum of evidence that one needs to have in order to show that. The standard, again, is the mantra that you heard from Jonathan, that you read in the decision, which is that the person to whom the information was given was a, quote, trading relative or friend of the tipper, okay? And the quantum of evidence, the court said, if you have a trading relative or friend that you give the information to, then the jury can infer, not that it must, but it can infer that a personal benefit was conferred on the transfer of that information. So now that we have kind of the table set with that, let's talk about what the court didn't answer. Virtually every case has some standard that you say is, what the heck does that mean? Here it is, who exactly is a trading relative or friend? What the heck does that mean? This will be a difficult one to answer in a number of cases that come up that are currently pending. Many of them have sought additional briefing or have asked for a stay or whatever. during the course of the Salman case in order for the U.S. Supreme Court to shed more light on that. And they really didn't shed very much light on that because in the Salman case, that answer was very easy. You had very close relatives/friends who were trading that information. It really was not a close case on the facts. But consider, and we'll talk about it in a couple of slides, what about, a Facebook friend? Does that, constitute somebody who is a trading relative or friend? What about your business acquaintances? What about your neighbors? Does it matter if it's a neighbor that you have over for dinner versus the one that you're suing because their shrubberies to hide between your properties? So that's just by definition going to be a very qualitative, a very fact-specific inquiry from case to case. The next question that we don't know is if that tipper is in fact a trading relative or friend, does it per se satisfy the personal benefit test? Court said that the jury can infer it or it may infer it, but not that it must. And as Jonathan was saying, in some of these instances you saw a definite predilection, at least from Justice Alito, thinking that if somebody is at least somewhat close, that you really do need to infer that it's obvious that they will get that personal benefit. I'm not sure if that's entirely true, and future cases are going to test that. The next question is, okay, if the tipper is not a trading relative or friend, what analysis applies? The analysis in Salman, and this is important to keep in mind, was very unique to the classic definition of insider trading, i.e., confidential information that is taken in breach of a duty, and in particular in breach of a duty of loyalty. That's a different theory than misappropriation, which is just you took information that wasn't yours, okay, whether or not there was a duty. So there's a real question as to whether this analysis in Salman will really be applied in the misappropriation context. There's a case coming up against the SEC investigation and claims against Leon Cooperman of Omega Advisors that you should keep your eye on. I think it's going to test that misappropriation theory. Number 4 is the same thing, just in a different format between the classic and misappropriation theories. And if there is a person who is not a trading relative or friend, under number 3, what other, do you get to be more closer to the standard articulated by the government, i.e. everybody is liable unless there is a corporate purpose that they can identify, or is it something broader than a trading relative or friend, but something less than the entire world who discloses information without a corporate purpose? And then finally, what about the other aspects of Newman? Newman did 2 things. It articulated a test of what a personal relationship needs to be that the Supreme Court in Salman rejected because it was too narrow, it was too focused on monetary benefit. The other thing that Newman did, though, that the Supreme Court left alone, and I think they need to leave alone, is the requirement that remote tippees must know that the original tip by the tipper to the initial tippee was made in exchange for a personal benefit. Because like we heard from Dirks, there is legitimate disclosure of inside information, and unless you as a tippee know that that information, even if it's inside, was not legitimate, you can't be held liable. So I think that that part of the Newman test will survive into the future. We pose here as a practical question probably the nub of what we are going to see in the future is really, it's where the rubber hits the road. Where you have a tipper who shares material non-public information in confidence with the tippee, with no intention that the tippee trade or no instructions that a trade be made, folks sitting around at a bar, and you've got one guy who's an insider over at, Intel or at Apple or at EMC or, whatever the large company might be. And, maybe they're just kind of shooting their mouth off a bit, and some of those, drinking buddies go out and trade on it. What about that person? That's a lot different than what the Salman case looks like. And is mere recklessness enough? Is ego gratification of simply, shooting their mouth off? Does that create a personal benefit? These are the issues that are really going to be tested in the future. So that's what we're going to be looking for, and we thought that we'd bring up a couple of cases that are currently pending where some of these tests or some of these fact patterns are going to be tested. In the Martoma case that Jonathan talked about that he actually worked on, this involved an insider for a pharma company who served as an expert in one of those expert referral networks that hedge funds use. They consult with people inside companies. They want to learn about the industry, and sometimes they want to learn about the company. And Gilman, who was the tipper, was one of those experts. But he took it beyond just simply serving as that expert in return for money. He was getting money from that to the hedge fund portfolio manager, who was Martoma, and gave him information. Martoma really, really recruited him and groomed Gilman as his tipper. And so the lines between financial benefit or that kind of tangible benefit really started to blur. It wasn't just a professional relationship anymore. It became something more than that. Jonathan, I know that you wanted to, if there was something that you wanted to talk about with respect to that case, please feel free to chime in.
Yeah, thank you, Beth. Yeah, one thing just to be clear, the trial evidence was that Gilman, the payments that Gilman received were not directly from the defendant Martoma, but that was his consulting fee at the rate of something like $1,000 per hour from the consulting network that Gilman participated in. And just briefly, the government takes the view that there are two separate prongs of personal benefit that inure to Gilman. One as a friendship, and the other as the pecuniary benefit. The pecuniary benefit meaning something like they met 40 times at the rate, that Gilman's rate of $1,000 an hour from the expert network. But on the friendship one is more interesting. It raises questions as in whose mind is one a friend, or is it something that's either subjective or an objective finding by the court? So in Martoma, in a post-trial motion, the Judge Gardefee in the Southern District of New York, he found that Martoma and Gilman had developed a real friendship, he said, based on a number of these sessions that he had with Martoma. And in Gilman's mind, he testified that there was a relationship that had fostered over 2 years. There were more interactions where Martoma was telling him he wanted to be closer, and that he said that he wanted to become his friend. At least that's what Martoma said, and that over time Gilman had said that Martoma reminded him of his first son, who was bright, and also, as it tragically turned out, had committed suicide. So, of course, Martoma takes the position that none of this was meaningful. It's not the kind of close relationship that Newman demands. So this will be interesting to watch out as to follow as these issues play out. Of course, the government's going to want to say they're always friends because that's the broader kind of easy slam dunk. But in this case, they argue both grounds, pecuniary benefit and the friendship as well.
Yeah, and that case is currently pending before the Second Circuit, who, in the wake of the Salman decision, asked both sides to submit additional briefing on the impact of Salman on that case. So watch out for that decision, which presumably will come down sometime in the next few months and is a very important one in the pantheon of cases. Another one that is obviously of very high prominence is the Gupta case. And I'm going to stop right here just to remind people that if you want to submit any questions for us to address, we've only got a few minutes left in our time period for this webinar. So if you do have any questions that you'd like us to talk about here, now's the time to type them up and get them off to us so that we have a few minutes at the end in which to address them. But in the Gupta case, as everyone will recall, this is Raj Gupta, who was the chairman of McKinsey, but who also sat on the Goldman Sachs board. Now, he is an immigrant. His family was an immigrant from India. Raj Rajaratnam was an immigrant from Sri Lanka. They both hung together in similar social circles. They were very much part of the same kind of sect and had many interlocking relationships. I'm not sure that people, at least initially, would have considered them to have been friends, but they certainly became close business associates. Over time, they then invested in a private equity fund together. Again, query whether that creates a, quote, friendship of the type that Dirks and now Salman contemplated. When Raja Gupta sent along to Rajaratnam inside information that he learned, that Gupta learned from his Goldman Sachs board meetings, there's no specific evidence that Gupta got anything from that other than that kind of, belonging in the same circles, which presumably they would have belonged in anyway because they're both, very wealthy, very well-known, very talented, and very accomplished professionals within the same kind of immigrant community within New York. So it is, this one is a far closer one than many other types of relationships, and one, again, where there was just absolute no specific evidence of what Gupta would have gotten in return for tipping off Rajaratnam in connection with the information that he got from the boards. We wanted to highlight as well two other cases that are currently pending, both in the Southern District of New York. Obviously, at the trial court level, you have U.S. versus Slane, U.S. versus Zhao. Both of them are going to have very specific fact patterns around what is this, quote, trading relative or friend. Neither one of them were relatives. Both of them were potential, I guess you'd say, friends, business friends. And what exactly does that mean? So you should keep an eye out, again, for those decisions as they come out. And there are others as well, pending in the various different circuits and trial courts as well. So, in conclusion, here are the takeaways. First of all, the Salman decision is a very narrow decision, really applicable to a set of facts that I think most any one of us, if we were on the jury or as a judge, who would have concluded that there was a close personal relationship that translated into becoming a trading relative or friend. In fact, it hit both. They were both trading relatives. One was the brother-in-law, the other was the brother, and friends within that familial relationship. And so on that score, the decision was somewhat easy. But for the broader implications is that we did not get an awful lot of guidance from the court as to what a trading relative or friend might be, okay? And as we talked about before, another real question is if, in fact, you find that a person is a trading relative or friend, or that they actually got money, or something as explicit as that from the information sharing relationship, then what kind of presumption does that create? Is it just a factor with the jury, or does it create something more? Again, Justice Alito seemed to tip the scales a little bit in his assumption that the benefit was an, quote, obvious one to him. The next takeaway is that Dirks obviously is in full force and effect with the in the wake of Salman, but Newman will also have some impact. Newman in particular, less on the standard of what constitutes a personal benefit, much more so on what the tippee needs to know in order to be held liable for trading on information from the tipper. When you have, and the next point is when you have a case of attenuated relationship, obviously defendants are going to argue for a higher quid pro quo type of standard for the government to prove. The government will push back on that. And as before Salman, and as we talked about, those cases against the downstream tippees, now that you have the Salman court really coming back full force and saying you need to have that personal benefit, and it needs to be one that is, in essence, a breach of the duty of loyalty on behalf of the tipper, those downstream tippees are going to have to be proven that they had knowledge, not just that the information was material non-public information, but that it was taken in exchange for a personal benefit. So when you start getting, one or two or three steps removed from the original tipper, that's where it's going to be much harder. It's already hard, and now in the wake of Salman, I think you'll continue to see the difficulties in trying to reach liability or convictions against those downstream tippees. Anything else, Jonathan, before we close out?
No, I think that's good. I see a question here that we can at least start to address. I don't know if you can see it, Beth, but maybe if we have how much time do we have?
Oh, okay. We've got like 2 minutes. We have a person, one of our attendees has a question. It says, what if you have a person with inside information who goes to the same bar nightly and shares tips and information with the bartender? Unknown to the tipster, the bartender goes and makes millions on the tip. The bartender gives his customer free drinks to ensure that the customer returns. Guilty or not? This is what very similar to that hypothetical that we were talking about in the first slide after, once we started talking about the individual cases that are pending. You've got two issues here. Number one, you've got some guy getting, drinks from a bartender, but bartenders do that to a lot of people. They just want customers to come back, okay? It's not necessarily in response to giving him information. It could just be because he likes getting monetary tips, not informational tips. The second piece, and I think that this is the harder one that we were talking about before, what level of knowledge does that tipper need to have that the person to whom they are giving information may in fact be trading on that? The Supreme Court in Salman talked about, quote, trading friends and relatives. That implies some level of knowledge that information that's being imparted by the tipper is going to be traded on. Now, perhaps recklessness is enough. This guy who's the customer and is sharing information, one can argue that he certainly is reckless unless he told the bartender, hey, just between us, don't do anything about this, but, I'm telling you, blah, 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 blah. So, one could certainly argue that person was reckless in doing so, but was he really a friend with this guy? Was he really getting something in return other than free drinks that anybody might get? I don't know. That's...
I would take a slightly different view from that and be a little more hesitant. And I think there's knowledge to be inferred based on essentially the nightly activity of the insider, night after night, to be sharing inside information. and look to the purpose, the state of mind of the insider, the tipper. Why is he doing this? You wouldn't think it makes sense to do it for a few drinks, but night after night it adds up, and I wouldn't put it past prosecutors or the SEC to find that as value ongoing in exchange and try that case. So certainly wouldn't want to be that insiders should go to another locale. But I think there's a fair inference that there's going to be knowledge, whether it's willful blindness or conscious avoidance, but there's got to be some knowledge on the insider's part to be doing this night after night, knowing that at least the first part is he shared the confidential information, and in exchange for drinks, there are prosecutors who would try that, I bet.
Right. What's interesting is, most of the cases that have come up and reached resolution, whether it's at trial or on appeal, are not this close. I would say the Raj Gupta case is probably a little bit closer, although they had this guy, kind of dead to rights in terms of the information that he was giving, and it was highly sensitive, and so there were a lot of kind of different factors than simply going into a bar. But this is a close case. But within prosecutorial discretion, absolutely, would they have the ability to go forward with a case like this?
And they would also, obviously, I would just add they would want to obviously prosecute the trader, the bartender, as well as the insider. So I think you can't do one without the other.
Exactly. So with that, I think those are all the questions that we had on this. We thank you for attending this. We hope that you think that it was helpful. I think that there are, Kayla, are there surveys that we have that folks can fill out?
Yep.
Okay,
so,
great.
Again, you guys can reach out to Jonathan or Beth with any questions, or myself. A copy of the PowerPoint presentation will be on Foley.com within 2 to 3 days. The recording of the presentation will also be on Foley.com. Any questions regarding the CLE credit can also be directed towards me. And again, Beth and Jonathan would love your feedback. So at the end here, if you don't mind completing the survey before you exit out of the web conference, we'd appreciate it. And we thank you for your participation today.
Kayla, will there be another opportunity to put the code down for CLE?
Sure, let me give it to you right now. I know there are some people emailing me. They didn't quite hear it perfectly, so I will repeat it one more time. The code is R as in red, E as in elephant, O as in orange, Z as in zebra, B as in boy. And because the polling question closed, you can email that to me. My email is khooven, Huven, @foley.com, and I'll make sure to track all of those for you.
Great.
Okay, thank you all.
Thank you.